Let me welcome, the Savrala members and my colleagues for having, honored this invite. And as you all know, my name is Sandilen Savanna. I'm the General Manager of Savrala. Thank you once again for honoring this invite. As per my invite that was circulated just about a week ago, you all know that on the 1st of July 2021, all South African businesses will be legally required to start processing, handling, and storing personal information in accordance with POPIA. This includes ourselves as car rental and leasing and the leasing industry. With the deadline for POPIA, fast approaching, we have, organized to at least someone who is quite good at this to help the industry. So we've arranged this important information session where, Savanna Stevens, who's the senior associate at Clyde and Company, will take us through, the POPIA Act. I have requested Savanna, to ensure that at least she accommodates everyone, big and small. Perhaps just a few words about Savanna. Savanna is the senior associate at Clyde and Company, South Africa, with a focus on corporate, commercial, technology, and data protection. Savanna specializes in data protection and privacy laws. She has also hosted a stakeholder event with members of the information regulator. She has experience in advising multinational corporations on the effects of data protection regulation concerning Europe, South Africa, and other African jurisdictions' data protection regulations. Savanna has conducted seminars for clients on the data protection obligation under South Africa's Protection of Personal Information Act, African data protection laws, and the comparison between POPIA and GDPR. Savanna has arranged and hosted a data protection event with members of the information regulator in 2020, where she was a speaker. Savanna advises all aspects of privacy and data protection in South Africa. She has worked with clients in a broad range of sectors, including healthcare, financial, emerging technologies, hospitality, retail, industrial, manufacturing, media, and entertainment. She has assisted clients with data protection compliance projects, which ensure that all the necessary systems and procedures are in place for compliance with POPIA. So in closing, very formidable sort of introduction, Savanna commenced her articles in 2015 and was admitted as an attorney in May 2018. She holds an LLB from the University of KwaZulu-Natal. She gained insight into application and implementation of the European Union's General Data Protection Regulation during a short secondment in Europe before she joined Clyde and Company in January 2021. Savanna was a senior associate at DLA Piper. As I've indicated, I think I've asked Savanna to cover and unpack the implication of POPIA generally. I've highlighted that her presentation not only focused on larger members, who may just be geared somehow, but there are smaller members as well who may not be yet properly proficient in the requirements of POPIA and ensure proper understanding of the requirements of POPIA to achieve efficiency and expedite their compliance processes. So without any waste of time, I'd like to just hand over to Savanna, and I'm sure that we'll find a whole lot of benefit as we gear ourselves for this readiness on 1st July. Savanna, over to you. Thank you very much.
Thank you. No problem. Thank you very much, Sandile, for that lovely introduction. I felt very good to hear those good words about me. Just for the moment, I'm joined by my colleague, so it's Bruce Martin. He's one of my candidate attorneys in my data protection team. So it's a good opportunity for him also to learn and kind of hear some of the questions that you might be raising so that we can kind of deal with these practical scenarios and concerns from a compliance perspective and work towards assisting some of you down the way. The intention of the session today is to be a bit interactive in the sense of please feel free to ask me questions, stop me as I go along for clarification. There are a few questions that I would like to throw out to the audience. To the extent that you want to raise a question or give a comment, you can do so in the comment bubble box, or you can unmute yourself and speak on the session as well. But the point is to ensure that we just give you practical ideas of exactly what POPIA means to you, and as well as what can you do between now and the 1st of July to get to a compliance journey that's going to be compliant from the 1st of July 2021 when POPIA becomes effective. Now let's just great. Okay, so I think what's great to kind of start off most presentation is just to understand the context in which POPIA comes into play. And as you can see on the screen, this concept of data protection and privacy isn't a new subject. And the reason I want to start with this concept is just for you to understand that these concepts of privacy and the way in which you deal with people's personal information or entities' personal information has been a concept that's been around for a long time. What's happened with POPIA is that it's just basically encouraged and emphasized some of these behaviors of how you go about processing personal information relating to data subjects. So you kind of see the movement of the law from common law. We're talking about the rights to privacy, then the right to privacy as it entrenched in the Constitution, and then obviously with the enactment of POPIA, we get to see how that comes to life. What I do like to just remind most parties when they're trying to conduct a compliance journey is to remember that there's an existing framework and context in South Africa in which you implement any journey. We're not asking you to restart your processes or redo certain things in a way that you've never had to do them before. The structures are already in existence in some of the particular laws. For example, we're talking about in terms of the Consumer Protection Act, when you laptop and join immediately. Thank you. Oh, we're back again. Great, awesome, perfect. Thank you.
There we go. It's back. Cool. Share screen.
Yeah.
Yeah.
Excellent. Great. I think we're back on track. Apologies for that, everybody. That was weird glitches of the system. I'll just pick off where I left off in the sense of talking about the other applicable data protection laws. When we talk about those applicable data protection laws, we're talking about Consumer Protection Act, the National Credit Act, which already has certain constructs of how you process certain types of information, credit behavior, that kind of information under the National Credit Act, as well as how you engage with certain consumers under the Consumer Protection Act, as well as those voluntary data protection provisions that exist in terms of that legislation. Now, what I always try to do is explain that in the context of South Africa, there's other data protection laws that exist in the world, for example, the GDPR, but also in the sense of in our neighboring countries. So there are actually quite a lot of developments around the African regions as well, in a sense of trying to develop and understand that this concept of protecting personal information is becoming a very important aspect for the region as well. So we are kind of aligned with our other counterparties in the rest of the region, but it's important to note that when you are engaging with your other colleagues in other jurisdictions, that you're able to engage in a sense of in the level of a market standard across the board, where you're sharing information with different parties across different regions as well. So in order to kind of place ourselves in the context of what is POPIA, I always think the best place to start is just with your key definitions. So the four important key definitions that we're going to go through is what is personal information. And I think that's the core definition around why we're looking to protect this personal information. Secondly, we're going to talk about a special category of personal information, which is called special personal information, that has a bit of heightened sensitivity in the way in which you process that information. And then the other concept is processing. And these are the types of activities which would be subject to the application of POPIA. And the concept of processing is just a very important concept to kind of grapple with, because once you can understand what is captured or caught by POPIA in the sense of what activities you're conducting on a day-to-day, then you understand the implications of POPIA in respect of your activities going forward. And then lastly, we're going to just deal with some of the role players, which is obviously a very important aspect to understand which role do you play as an organization, as Savrala, as a member of Savrala, dealing with certain customers, yourself. How do you place yourself in the sense of what is your responsibility in the law as a particular role player? So just touching on the concept of personal information. So personal information is a very broad concept, and it's not intended to be a limited definition. So you can see it's quite a wholesome definition. And basically, to simplify it, it's any identifying information relating to a certain data subject. And this data subject could be a customer, it could be the entities. So basically, whatever the member is, the association, certain regulatory bodies that you submit information to, any credit bureaus, service providers, etc. And the personal information we're talking about is information relating to race, ethnic origin, your sexual orientation, your culture, your beliefs, personal opinions, views. And then if we just take it from a practical sense, we're also talking about the certain information certain customers submit on an application form for example, they want to take out a rental contract. They would have to provide you certain information like their credit card and account details. They'd have to provide you with certain type of history, potentially, financial history, as well as just background history. And in some instances, you'd have to go potentially and vet that information, maybe with the service provider, like, credit provider, somebody to vet the credit history of a relevant person. Or in some instances, if you're talking about employees, you're talking about looking at the criminal background checks of your relevant employees to the extent that you need to look at that for your organization. So it's quite an involved concept of what could personal information be. But I think if you can practically understand that if it has an ability to identify a data subject, then it's personal information. The fact that I wear glasses is it's a personal information. It's specific to me as a person.
Yeah, I think just to add on, I think the point of that POPIA extends to juristic persons is quite important, because it also talks about your business relationships with other companies. So if you're a member and you're dealing, obviously if your client base is not just people, natural persons, it's companies as well. You must also look at the processing activities in relation to what sort of documentation are you requesting. Because that obviously that identifies a company. It also then is captured under POPIA, and the processing activities need to be compliant therein.
Yeah, absolutely. And one of the points I think I just want to raise as well is that just because personal information is in the public domain doesn't mean that it's outside the ambit of POPIA. It's very important to understand that any information that's available on SIPC, registration numbers that are generally publicly available, that information is still subject to it's still subject to the application of POPIA, because it is personal information relating to a relevant entity. Okay, so the other concepts we're just going to go through is the processing. So processing is basically any activity in relation to personal information. Now, the best way to kind of understand this is to compartmentalize your activities. So if we just talk about a scenario of a customer walks in, or a customer submits an online application for a lease agreement, and they have to submit a set of information. That information that you're collecting is a processing activity. Then if you decide to go and vet that information, and you've got to go share it with another service provider, that's another processing activity. And then if that information is then stored on your books for a period of time and you've gotten the consent to direct market to that person, that's another processing activity. And it basically just keeps flowing on. So any sense of activity that you engage with personal information really is processing information. Another practical example I always think is helpful is when somebody prints something at the printer and you pick it up by mistake. The ability of picking it up, noting that it's not yours, and discarding of it is still an activity of processing, because you've now taken this information, you maybe read a few lines, you've identified the data subject that it relates to, and you've now discarded it because it doesn't relate to you. That small activity, the small realm of that processing activity will still be captured under POPIA. The next point is just to talk about the type of categories of special personal information. And this is just information that requires a heightened sense of protection because of the sensitivity of it. We're talking about religious and philosophical beliefs, the sexual orientation, your ethnic origin, your trade union membership, political persuasion, and then also the criminal behavior of certain data subjects. So obviously, when we're talking about those kind of concepts, you can also automatically assume, just by having reference to it, that it would need some certain type of protection. Importantly, what we don't see is that you don't see financial information or credit history or those kind of things being captured under special personal information. However, there are certain provisions under POPIA which do identify, that type of information does require a bit of protection or more onerous protection because of the ability of that information being hacked or being used for identity theft and fraud and all these kind of scenarios that the worst outcome for a relevant data subject. So whilst it's not part of the category of special personal information, from a practical perspective and going forward, and generally under your obligations under the National Credit Act and other legislation, you'd still need to ensure you keep the same sets of standards and compliance, especially if it's more onerous than what is set out under POPIA.
I think just for a brief example, if a customer is unable to pay, for example, due to ill health, and you request any sort of medical records justifying that, or if your policies and procedures require you to ask for that, the storage and the request and the kind of receiving that personal information is covered, would be classified as special category, special personal information, and would be subject to the initial prohibition that you can't process, and then obviously you would go through the exercise of establishing a lawful basis
for processing that information. Correct. Okay, so now we're just going to deal with a bit of the parties and the role players. And on the left-hand side of the screen, you can see a few of the list of parties in the sense of the activities of processing of personal information. Now, I think the most important person in the realm of personal information is the data subject, and that's the person to whom the personal information relates to. Now, just important to note that in South Africa, we actually have a more onerous requirement than in any other jurisdiction really in the world, and that we look to protect the personal information of juristic persons. So it's quite an unusual element, but under our law, we recognize that information of companies and entities are also subject to certain types of hacks, fraud, or any type of like data breaches in a sense, and that also requires a sense of protection of such information. So it's just important to note that whilst you might, for some of the bigger companies, whilst you might have processes in place from a GDPR perspective, you still have to go that extra step of ensuring that you then attach or extend that protection to your personal information relating to juristic persons. So the other two parties are just the parties that actually process the personal information. So what we're talking about is the responsible party. And as the name actually indicates, it's the person who's responsible and accountable under the law for the processing of the personal information. A practical example of who a responsible party is somebody who determines the specific requirement or collection. For example, if you want to be able to provide a service to a customer, you determine the need for it, and you determine the purpose is to be able to provide a service, to be able for a commercial gain or commercial need. and you determine that the way in which you're going to do it is facilitate that engagement with the relevant data subject through an application form or advertising to them, etc. And once you determine the purpose and the means, you're then the responsible party. Now, what happens is when you involve another third party in the area of processing, this would be your operator. So this is somebody who's acting on the mandate and the instruction of the responsible party. So this is a very simple example is somebody, if we're talking about in a HR context of a company, this is your payroll provider. They are actively just acting on your instructions. What you have in-house is potentially not a software management system, etc. So you outsource the function, but the whole activity and the type of information that's being shared and that activity that's being conducted by the payroll provider is limited to your instructions to assist you with either making payments, doing all your tax affairs in respect of your employees, income tax reports, etc. So that person is acting on very strict instructions. Another example is any party that is used, so it's like a cloud service provider. Should you be moving to, from a traditional sense of storing the files, etc., that could also be another example of an operator. A very simple example as well as somebody who's involved with any archiving of your personal information. For example, you keep lots of files and records of your relevant transactions. You have to keep them in terms of the law for a specific period of time. You want to archive them offsite, etc. That person is acting again on your instruction. Nobody will have access and read that information. They're purely acting on a service of archiving that information for you. The other role players we're talking about is the information regulator, and that's the Data Protection Authority for POPIA. I don't know if, I'm sure most of the members on the call are aware, but the regulator has been very active in the past few months. We're trying to ensure they have a communication strategy for all data subjects to understand the implications of POPIA, but at the same time, they're very active in investigating a lot of entities for compliance with POPIA. So whilst they potentially can't enforce the provisions of POPIA, they are still considering complaints, they're engaging with parties. You could see there's a lot of engagement on the WhatsApp policy, etc. So it's important to note that from the 1st of July, they will start taking even more so of an active role. And I do foresee that they're going to start enforcing the provisions and start, handing out fines or initially starting to do compliance audits of certain parties or investigating matters and then taking it through to an enforcement committee and issuing certain types of compliance notices, etc. So that's a very important message just to tell most parties is don't think by the 1st of July there's going to be an additional leeway. From most of the discussions with the regulator, they've actually indicated that they really do want to enforce it from the 1st of July 2021. The last role play, and this is relevant for the responsible party, is the information officers or the deputy information officers of an organization. Now, the information officer appointment is, in terms of the private bodies, is an automatic appointment by the head. It's basically the head of an organization. And if you don't want the head of the organization to be the information officer, you can then authorize another person in the organization to be your information officer, but the accountability and liability will still sit with the head of the organization. But what's important when you're going about this process of compliance is identifying the right person for the job or the right candidate to be able to take on the roles and responsibilities. But what the great thing about the structure of POPIA is that they allow for you to have a sense of delegation of these duties downwards to various deputy information officers. And most organizations are doing that through setting up like an IT deputy information officer, an HR deputy information officer, or the like. But what is another solution as well is that if you're a small organization who's trying to come to grips with the concepts of data protection and POPIA, is you can outsource the functions in a sense of dealing with the complexities, the questions, going through a compliance program through a legal service provider as well. So the regulators come out and said, whilst you have to have a formal appointment and registration of a person or an employee of an entity, that the roles and responsibilities can be sourced out to somebody who might be more specialist in the area, and then you can lean on that person to help you through your journey. Because again, what's important to understand is POPIA is an ongoing journey of compliance. From the 1st of July, nobody's going to expect all companies to stop their activities. It's almost going to be carrying on all the processing activities in a manner that's more compliant under POPIA.
I think one of the practical kind of checklist action items that members should be aware of is that by 1 July, registration for information officers should at least be completed. And the information regulator in this regard has established a portal, an online portal, which is quite a simple sign-in and registration process. And that's obviously one of the compliance obligations in terms of POPIA is to have your information officer, whether it be the head of the organization or the appointed information officer, to be registered, as well as any delegation to deputy information officers. Their information must also be kind of recorded on that database.
Great. So now, just from a practical perspective, I just wanted to kind of unpack the concept of when POPIA applies and when POPIA doesn't apply. So in the context of, any sharing of the customer's behavior regarding your payment or non-payment. So we understand that there might be some sharing of maybe statistical or not statistical information, but in respect of saying, well, this is somebody who's a constant defaulter, and you alert other members in the correct forum, I assume. In that scenario, that sharing of the data, customer data that you have about your relevant customer with other members would be subject to the application of POPIA, because it's obviously identifiable information about the relevant data subject, and other members then make active decisions in respect of such information that's now been, shared amongst the members. Where you then involve other parties with, sharing with the service provider to create a database, or you just share it with external companies who potentially want to acquire certain databases as well. All of those activities are then subject to POPIA as well. Most importantly, I think, is when POPIA doesn't apply. So what I wanted to just illustrate with this point is that there are certain exclusions of POPIA or certain activities that are not subject to POPIA. And this is information where it's been sufficiently de-identified. So if information, for example, statistical information where identifying factors about relevant data subjects is removed, you're talking about a particular audience, how many sales have happened in this particular region, or how many rental applications have failed, or whatever it is that you want to share. As long as it's in a statistical format that's kind of anonymized, you almost kind of act outside of the ambit of POPIA. And in those kind of scenarios, you then kind of remove the onerous obligations upon yourself under POPIA. So it's always important to try and understand what activities can you almost minimize the type of information you're processing, and can it be minimized and anonymized in such a way that you're not really even processing personal information anymore. So just to illustrate the point is that POPIA applies to any personal information that's entered into a record within the Republic of South Africa by automated or non-automated means. And certain exclusions of POPIA is that any type of household, purely personal activities, any de-identified information, again, that's what I've explained, it's sufficiently de-identified and de-linked from the relevant data subject, the processing on behalf of public bodies for unlawful activities and AML kind of purposes, the cabinet or executive council's activities, judicial functions of the court are also excluded, and as well as the journalistic, literary, and artistic purposes. Now, what I want to do with this slide is just to quickly raise that there are 8 conditions for lawful processing under POPIA. So POPIA is not saying these are potential obligations. They're saying these are conditions for how you process. So it's almost a principle-based approach as opposed to obligatory requirements approach. And the intention behind this construct, which comes from other European data protection laws as well, is that they want you to create a culture of data protection and create almost a principal approach to the way in which you manage your processing activities. So I'm going to run through some of these concepts quite quickly, and I'm going to deal with more of the important elements of these conditions, the ones that I think most practical and most pertinent to the type of processing activities that you're conducting as the members. So the first principle is accountability, and that's just talking about, again, going back to my discussion initially about the role of the responsible party as opposed to operator, determining who's the person accountable under the law. And as per the principle, the responsible party is accountable for the compliance and the conditions for lawful processing under POPIA. There's almost a limited sense of what an operator will be found liable for under POPIA unless there's contractual obligations imposed between the parties. Again, this will be circulated after the meeting, but I think what I tried to do is give a very practical approach of what type of undertakings would you want to impose on the relevant operators if you are acting as a responsible party. So you've got the POPIA approach and then the GDPR approach. My suggestion is always when you're acting as the responsible party, you want to go with the GDPR approach in the sense of the most onerous best practice approach. But to the extent that you ever act as the operator, you want to go the POPIA approach because it's a more limited set of undertakings that you could impose. And most companies are starting to, engage with these kind of concepts of you using these principles and undertakings that you would start to see in most of your agreements and services agreements going forward.
Yeah, so just to add on that, I think it really forces the responsible party and the members of Savrala to look at and to consider their agreements with their suppliers and see what are the mechanisms for data protection. Are there any are there any that can be negotiated and contract and kind of amended to cater for your obligations to your the data subjects that you are processing their information on?
Absolutely. So the other point that we just wanted to quickly raise is that, and it's just a very important principle in that you must have a lawful justification for processing any types of information. So obviously the first prize by the regulator, I think generally for most companies, is to try to get the consent of the data subject. However, if it is not practical in the circumstances, you can rely on one of the other lawful bases, the legal obligation to perform the processing. So that's if there's a law that requires you to do so, certain reporting obligations to SARS, to certain regulatory bodies would have, there's almost like a legal obligation to comply and process that information. Processing which is necessary for the performance of a contract, which the data subject is a party to. The protection of the legitimate interests of the data subject. And I think the most important, most common one that we keep seeing is the processing by the for purposes of the legitimate interests of the data subject. And that another data subject of the responsible party or to a third party to whom it's disclosed. Now, this is a very common ground to rely on, and we see it most often, but it's important, and I want to almost ensure that parties understand that when you pick this ground, understand that it's not a catch-all phrase of catching everything that you could do with the personal information because it's in your legitimate interest. Try to come up with a reasoned and sensed approach of, is it unfairly limiting the data subject in a way that it's not justified? And in those kind of scenarios, I wouldn't always say that it would be legitimate in those circumstances. But most of the time and most of the activities that you would be conducting would actually could very generally be based on that lawful justification. And important to note that consent must have the ability to be withdrawn. And certain of these types of lawful bases for processing can actually be objected against by a data subject. And that's where the data subject access rights comes into play. Now, I just wanted to just pull up the slide just to note that when you are processing special personal information, there's actually a prohibition in the Act, which says you can't process that information unless one of these applicable grounds exist. So here you see those grounds kind of get limited. And that's because the law doesn't want you to just haphazardly constantly go and process this type of special personal information when there's no real lawful basis. So the legitimate interest ground falls away. We're looking at more grounds like consent. If we're talking about race and ethnic origin, you're talking about grounds in terms of like BEE legislation or the Employment Equity Act, doing your certain reporting obligations as an employer, et cetera, et cetera. The other point that I wanted to raise, and it kind of ties into retention, is purpose specification. So you need to, as long as you have your lawful basis in laws, that could be consent, legitimate interest, etc., you need to have a specific purpose for the processing. And the reason for this is that there needs to be a reason why you're collecting certain information. And as you come up with that reason, you then determine, once that reason has been completed, there's no longer a need for me to continue to keep that information going forward. So that's why it ties up with the retention policy and retention period requirements. So what's important to understand in terms of retention periods is that, again, you have to look at the existing legislation, which specifies the prescribed period of time. So POPIA basically says you should not keep the personal information for longer than it is necessary to give effect to the purpose for which you collected the personal information. So if you can't come up with a reason or an additional set of purposes after the fact, then that kind of the grounds for keeping it or continuing to retain it or process kind of falls away, subject to what the law says if you have a requirement to continue to hold it. For example, the Companies Act requires 7 years for certain companies' documents. The Tax Act also imposes its own obligations. So those are things to still bear in mind, but you keep the principled approach under POPIA in that, am I keeping this, am I just holding on to clients' data, dormant clients' data, indefinite? Do I intend to contact them in 3 years? Or do I want to just keep this information for purposes of one day hoping to, that they will return, etc. Those things you just have to kind of rethink through and start to kind of look at your records, old records, and kind of sift through that from a compliance perspective and get rid of that, because you don't want to be found foul of the law for holding on to something you actually don't even need or want to process. This kind of leads into just to the purpose specification, and that if you are going to process the personal information for another basis, another reason, it must actually accord with the original purpose, or there must be some type of other basis for processing it. And those are kind of the exceptions to this rule which apply. And it's basically if you have some type of consent of the data subject, or if the information has now been made public by the data subject, et cetera, et cetera. So there are some grounds to further process, but you just have to keep ensuring that every activity is then justified under the law, under all these principles. An important principle, again, under POPIA is the information quality principle, which is basically just ensuring that the information you hold is complete, accurate, not misleading, and updated. And this is where data subject participation has become so important. And engaging with your data subjects in respect to the information you hold is also so important, because they will be the only ones to tell you information is inaccurate, incomplete, or potentially misleading. So you have this obligation, but your engagement with the data subject will help you reach your compliance for this purpose of information quality. And a very important point, and I think this is the one I want to just stress a bit more, is the openness requirement. And the openness requirement is I think quite flexible in our law, in a sense of you have to ensure that when you collect personal information from a data subject, you comply with these notification requirements, which is basically to inform a data subject of certain prescribed sets of information which is available on the screen. So you're talking about the categories of personal information, details of the responsible party, etc. And that is basically in the form of what you would see as a privacy notice. So the best practice approach is almost an outward-facing privacy notice used in a website or in a set of terms and conditions, however it is that you want to facilitate it. Importantly, our law is not prescriptive. It just says you have to take reasonable steps to inform the data subject of these sets of information. So how you go about doing it from your own perspective, in a sense of what is practical and reasonable for your organization, must be borne in mind when you go about doing this. You don't need to follow the principles of a bigger multi-jurisdictional company. You can kind of keep it very simple and easy and effective so that you are able to achieve this openness.
So for example, if you're a larger organization and a larger member of Savrala, and you have a website, a live website that you regularly update, you could house your privacy notice on that website. So when and refer data subjects to the privacy notice housed on the website. If you're a smaller member, you could, and as Savanna said, you could take reasonable steps, and that could be having the privacy notice printed at your premises. So when your customers, who are your data subjects, come through the door, they are notified that if they are handing over any of their personal information, this is kind of the notification of that, and then it obviously discusses what will be processed by the responsible party, being you.
Excellent. So I think this is the side I just want to stress the most about. And I've got a really great tool on which to kind of reflect the security safeguards that you can implement for big and small organizations. So basically, every entity that's subject to the protection or subject to POPIA is required to take reasonable, technical, and organizational measures to protect the personal information. And the way in which we could do this is basically just taking very simple steps. Now, what I wanted to just demonstrate on this photo, and I'm not sure that we have the capabilities of hearing other people, but I'll just start to point out from this picture certain issues that can be quickly fixed in a big and a small organization. So if you look at this picture, you've got an open laptop that's not locked. Immediately, you could think of an ability of making sure that any computers that are open with personal information are locked when you walk away. You've got access cards on the table. You've got passwords as well. That is just revealing, and it's an ability for somebody to come up, get access to the information, and maybe if it lands up in the wrong hands. You've got confidential data and bin. You've got your filing cabinets, which should be under lock and key. Should you have, physical storage of documents, that's also sitting in open filing cabinets. You've got the server room open. You've got printed documents, etc. So what I want to just demonstrate from this picture is that from a technical perspective, you can put IT security measures in place. But from an operational perspective, we're talking about simple means in which you can process and do it process the personal information in a manner that will ensure the protection of that information. So it's a very simple steps, and hopefully organizations can start to come to grips with this and deal with or teach their employees how to kind of adopt this culture of privacy and start to, leave away these bad habits of leaving passwords on tables, etc., etc.
Yeah, I think we've seen from our experience that it's really the low-hanging fruit kind of situations where for example, in the slide where leaving computers unlocked has led to security compromises. Having a password that you use for everything, and I think we're all kind of guilty of that offense. But it's encouraging those which like those data hygiene habits, those safe kind of POPI compliant habits. Another example of a security compromise is sending personal information in an email to the wrong recipient, where it seems like a very small kind of act, but in terms of POPI, that is technically a security compromise, and it's just being aware of these small instances of security compromises and knowing how to mitigate them, because these are the ones that we've often seen have led to the bigger a bigger problem, whether it be a hacking attempt by clicking on suspicious links, or not disposing of personal information appropriately when you're going through that exercise of looking at your records and seeing, is there any client information, company information that you still need at this juncture?
Absolutely. And I think the reason why we just wanted to put up some of those examples of potential security compromises is just for you to start thinking of coming up a very simple response plan. And it doesn't have to be a formal program. It doesn't have to be a written plan. It just needs to be a sense of, what do I do when something like this happens? I send the email to the wrong person. I've copied in quite a lot of sensitive information. I've sent it to the wrong customer. What do I do? And generally recall the email, but do you then take that extra step of thinking, okay, is there any reporting obligations under POPIA in that scenario? And basically under POPIA, the requirement of what is a security compromise, or in a colloquial term kind of concept of data breach, it's where there are reasonable grounds to believe that the personal information of a data subject has been accessed or acquired by an unauthorized person. So it's a very low threshold. And because of this low threshold, it's always very good to kind of have a sense of the response plan in an organization, because what you don't want to happen is your employees running off to the regulator to report the event. You want to secure the way in which the messaging goes out of your organization, but at the same time, you want to make an assessment of, can we live with this not being reported, or do we need to report it in these scenarios, et cetera, et cetera. So coming up with a plan of why, who, when, how is a very practical, just like a 5-step approach of, okay, this is what we'll do in this scenario, and this is how we will manage it internally, and we will then also comply with our duties under the law. So one of the last principles under POPIA is just the data subject participation exercise. And I touched on that initially when I was speaking about information quality. And data subject participation is one of the principles that have almost been encouraged and emphasized under POPIA. And this is the ability for the data subject to engage with the personal information that you hold about them. So they can actually request a record of that information. They can request certain information to be corrected, deleted, to be destroyed, when they're no longer authorized to, when you're no longer authorized to retain it, and all these other, these additional rights that data subjects probably never knew they even had under PIA. So PIA is the Promotion of Access to Information Act, and these two acts kind of sit alongside each other. So if a party makes a request for certain access requests, they could do so through the certain forms that would be almost attached to your PIA manual. So most organizations should actually have a PIA manual, which is basically meets all the requirements under the Promotion of Access to Information Act, which includes some of these duties under PIA, under POPIA as well. And part of that whole process is just to be able to allow the data subject to engage and respond and almost make certain requests, and for you to engage directly with that data subject in respect of those requests. So there are grounds to refuse, and you can kind of go through that process, and you're also entitled to charge certain fees, and you're also entitled to verify the data subject before providing that information. So there's a bit of engagement and a little bit of limitations on how these rights are being exercised, but at the same point, the regulator will focus quite heavily on this area because, it's important that the data subjects are then able to exercise these rights. And if you fail to never respond to these requests, that could put you in quite hot water with the regulator because, you failed to comply with this principle of giving access to certain information to data subjects. Now, I just wanted to just quickly touch on some other noteworthy processing activities, and it's just for your benefit of understanding that POPIA does have certain additional sections regarding certain types of personal information processing activities that are subject to an additional set of protections. So we spoke about special personal information and personal information relating to children in that sense of being, special category with this prohibition. But there's also certain activities that are actually subject to prioritization from the regulator. And certain activities where you are transferring information from South Africa outwards to any jurisdiction that potentially doesn't have adequate data protection laws. And as we stand today, potentially most jurisdictions don't have adequate data protection laws in as far as
There you are. That repeats us again. We'll try and reconnect. I think that's a very important part of the presentation. We'll try and reconnect again. I don't know what's happening now. We seem to have lost Savanna. If you could just bear with us, ladies and gentlemen, but I'll try and see if we can reconnect with Savanna.
I'm trying to reconnect now.
I think just to the members, we have just moved into our new law.
We've just moved into our new offices, so we are having some teething problems, and this seems to be one of our teething problems. Apologies, everyone. So I think just carrying on the point of trans-border flows, so we kind of addressed the point of trans-border flows as being one of the one of the subjects that are just subject to additional protections. And then the last thing was just to talk about automated processing activities. And that again is also subject to the stricter kind of sense of making certain decisions without any human intervention is also kind of subject to stricter measures in the way in which you go about these types of activities. Now, I think what's quite helpful and pertinent for organizations like yourselves is part of your direct marketing engagement with certain customers to be able to, get some type of contract going or just to kind of drum up some work in the market. Importantly, under POPIA, we're moving from a system of the opt-out regime into an opt-in regime. And one of the new requirements is that you'd have to actually approach the data subject once to be able to get their consent for purposes of direct marketing. And should the data subject never respond to you ever, you will basically never be able to get in touch with that data subject because they've not been consented to receiving direct marketing from you. There is an exception to the rule, however, and this is where any of your current database where you have certain existing sets of customers where you obtain their personal information in the context of a sale of your product or service, and you got it for the purposes of being able to direct market to them in respect of the same or similar set of goods. And at every point that you've engaged with that relevant data subject, you've given them an opportunity to object to the direct marketing. So these kind of sets of existing customers are almost excluded from this requirement of an opt-in. However, going forward, it'll be very important to make sure that where you are engaging with these data subjects, you ensure you include that link for them to be able to opt out of receiving the direct marketing information or documents or certain sets of communications. Importantly, this relates to electronic communications. So under POPIA, this opt-in regime won't actually regulate the requirements of normal traditional telephone calls, etc. However, you still need a lawful justification to be able to contact them in the first place. And again, we go back to those original justifications we started talking about in the beginning. Now, I think what's always great at the end to kind of discuss is just to talk about what are your offenses, what are your penalties under POPIA. And these are I think it's a way to kind of just remind yourself of what are the implications for non-complying. And you can see it can be quite harsh for smaller entities as well as for the bigger entities as well, in the sense of it's a 10 million rand fine or up to 10 years in jail time. This is for more of the stricter, more obstructive type of offences. And this is where you are failing to comply with the conditions for lawful processing in respect of certain type of account numbers. You fail to comply with an enforcement notice which has been issued by the regulator to you after they found you to be non-compliant with the law. It's obstructing the duties of the information regulator or potentially giving any false evidence when you're in any type of investigation with the regulator. So the other offences also can be subject to a fine of up to 10 million rand or up to 12 months in jail as well. And this is a breach of any type of your confidentiality obligations to the regulator, obstructing the execution of a warrant, or failing to assist in the execution of a warrant where the regulator is involved in any type of investigations. The last thing I think we just wanted to just kind of give you some last minute kind of tools and quick wins. And as we've stressed from the beginning, appoint your information officer, get that sorted, get them to get some training, where possible, sign them up for some other training, we do some training, there's some online training available. It's very good for them to be able to understand and practically implement their role from a day-to-day basis and register those parties. To the extent that you haven't done so, consider doing a data mapping exercise, which is just trying to establish in an organization what information is being processed, where is it flowing, how is it flowing, is it lawful? And part of that is doing an assessment of your processing activities, which is basically looking at types of activities against POPIA, principle by principle, and saying, do we have this right? Do we have a purpose? Are we collecting too much information? Can we reduce this, et cetera, et cetera? Conducting some type of data protection training for employees and communications. I think this is one of the most important things that I think the regulators also indicated, is that creating a culture of privacy in the organization and almost making it the DNA of an organization, in that you get the buy-in of your employees, because as we've said before, sometimes your employees are actually the weakest link in the organization, because it's their small slips that will maybe cause a bigger problem. So you can have the best IT security, but a phishing email is clicked on, and then you're in hot water.
Yeah, and it's a reputational issue as well, because I think that's we in Savanna and our discussions we've also been talking about that although it is perceived to be a big IT spend in the beginning, and any sort of company expense to do the assessment, to do the dating mapping exercise, it's at the end of the day is to guard against, as much as possible, to guard against any sort of compromise and the reputational damage that comes after that. I mean, we've seen a lot in the press with the credit bureau hack. And other bank hacks, it impacts the reputation that data subjects have, because I think privacy and safeguarding that privacy is becoming almost a commercial interest.
Absolutely, well. and that I think one of the things I just want to end off with is, as much as I think you almost want to kind of go on this compliance journey from to be able to comply with the law by the 1st of July. Important element and something to be able to market and engage with certain data subjects as well, and also engage with other service providers and entities, is to be able to show that you have these developed privacy programs, etc. Because it just makes sure that when there's any flow of information between entities or purchasing of information, etc., it's done in a manner where parties want to engage with you, because you've taken that extra step. You've not just checked the boxes for compliance, you've also taken the extra mile of, what can I do to make sure that it's a marketable approach for me? Now I can use this as a selling point to say I'm 100% compliant, or this is I'm on my compliance journey, etc. And data subjects will potentially also engage further with you on the basis that they feel you're going to treat that personal information about them with the integrity that it deserves. And maybe the last thing also I'll just say is that it's one of the last points we had as a quick one is, again, just trying to think back to that the slide I put up about those small security safeguards that you can just implement from a day-to-day. And if there's only one thing I can leave you with, or maybe leave you with for your employees, is start to doing those small things from a day-to-day perspective. And that's where we will start to see big differences. So I think this is when I wanted to just open it up to questions if there were any, and I was trying to rush towards the end, Sandile. I hopefully got towards a lot of information.
Thank you very much, Savanna. This was really very informative, and I do, I'm almost positive that I've just been receiving comments about how valuable the session has been. Perhaps, obviously I have, scheduled the meeting to take up to around 1:15 to certainly allow for this important part, which is the question and answer session. Just one thing, one of the key things we do as an organization is, obviously, I think I did highlight that to you as well. You may have touched on it somehow, but it's very important to us. The implications of, do quite a bit of sharing of information, sharing of renter behavior for risk purposes, sharing of payment or non-payment, between companies. I think it's quite important in our industry as well. We forever look at doing those measurements as well, working closely with some of, for instance, some of the companies you've mentioned, the likes of TransUnion as well. But I think it's important to just highlight what the implications are, just from me, and then we can take other questions as well.
Absolutely. So I think one of the points I wanted to maybe just raise, and that's a good point that you've raised now, is that in respect of your where you're sharing this rent information, I think, and this is the point where Savrala comes into the picture, is that through Savrala, you're able to share with other members and you're able to create this database and share very good information from a risk perspective. Whilst you are sharing that information, it's important to have some type of lawful basis to go about doing it. And that's where we talk about each relevant responsible party ensuring that they have the right to share that information alongside to the other third parties involved. And where I think it's important is in the sense of making sure that that transfer or sharing element is compliant, and then any continued use of that going forward is also compliant under law, and they have a lawful basis for that continued processing. Importantly as well is just to also say that you need to ensure that there's certain privacy policies and disclosures to the data subject, that there's going to be all these recipients of this type of personal information. And this can be easily solved through your privacy policies or your relevant documents, whatever documentation you wish to use to inform data subjects that, you know, we are part of an association. We might share it with members very similar to us for these particular purposes, commercial purposes, being able to make the best commercial decisions for ourselves going forward. And those are like the small practicalities of just in saying these are things you can continue to do. You just got to rethink about, is it lawful? Great, it's lawful. How do I go about doing it? Do I need to inform any data subject? And am I continuing to keep this information for longer than is absolutely necessary? And those are small principles you can adapt going forward.
Yeah. Let me not take members' time. I know we're still going to be engaged because there are certain things that certainly as an organization would like to look at. You know, we are very much driven by our code of conduct, as you may know, and these are some of the areas I'd like you to look at. But I think let's open this before, without taking much time, if there's any questions from the members. I don't know if there's anything from the chat. I think I seem to have noted that there's something in the chat. Let's just check if there's any questions. I'm not seeing anything. Perhaps whilst waiting for any members who may want to just come in and ask questions, let me repeat the fact that the recording is going to be made available. So is the presentation to all the members, those that have attended and those that have not. We have also, made this live on YouTube, and I'll try and ensure that at least that link is also made available to members. I think this is valuable information that the members need to reflect, on again on during their spare time, and just to ensure that at least they are geared, for come 1st July 2020. Perhaps whilst waiting, one of the activities that has taken place from an automotive industry point of view, just recently, there was a meeting that took place that involved all the stakeholders in the automotive industry. That includes your NACAM, your NAMSA, and all of those. But there was, in some hindsight, Savrala was left out of that, but we were at least afforded an opportunity for a separate session that dealt with, just Savrala, and where we were taken through basically, some of the key salient features of these substantive issues in the development of industry-wide code of conduct. I am going to be still in touch with members regarding that on our decision with regard to the code of conduct. I thought perhaps I must just ask you, just at a high level, what the requirements are in terms of just I'm not talking a Savrala code of conduct, but I know that the act itself does in a way encourage the formulation of code of conduct.
So and Sandy, I'll answer your question, and I see some questions coming up in the chat. So I'll answer yours, and then I'll answer some questions that are coming in. So for the code of conduct, I think it's a great piece of it's a document that's great for industries, right? So there's certain bodies that can kind of come together to understand these are the practicalities facing us with trying to comply with POPIA. And let's come sit around the table and come up with practical solutions of, how do we get around this? How do we inform data subjects in the manner that it works for all parties, that this is how we will comply with our conditions for lawful processing, but in a way that's still practical and doesn't affect our industry in a manner that's overly onerous. And that's what you're starting to see with a lot of these code of conducts coming through. We've seen the Credit Bureau issue their code of conduct. And I think over time, we're going to start to see way more industries coming together, because it just makes applications for certain exemptions from the principles of POPIA easy through this code of conduct. And in a sense, it just creates a level of joint thinking around practical solutions of how to comply, as opposed to thinking, trying to comply with it in your own space and trying to almost be overwhelmed by the provisions and the obligations. It's the best kind of manner to take it forward through these code of conducts. Sandile, I'm gonna answer some of these questions if that's okay. Great. Okay, so Gary Kemp has just asked, thank you for your question. Should a POPIA clause be added to our rental agreements and credit applications? So I would say definitely consider including certain wording that describes, certain of your POPIA obligations. My recommendation is where you are including those type of POPIA clauses in an agreement, my sense is kind of arriving at a policy with reference to that policy in an agreement, because agreements are quite difficult to keep changing and adapting, and you have to keep getting the consent of the relevant data subjects when you make these certain adaptations as the law changes. You almost lose that flexibility. So my preference, and from a practical perspective, is including wording to say, we will obviously comply with our obligations under POPIA in respect to the processing of your information, and how we do so is as referred to in our privacy policy, and then you can link them to the privacy policy, which then is available for adaptations over time. Where you're looking at consent, however, and that's where it becomes applicable for credit applications, is that's when you actually need like an informed opt-in consent, and that's when it's appropriate to include that kind of clause in your credit applications as well. So it's just about making sure that it's ensuring that you comply with the laws, but at the same time in a practical manner that works for an organization and is able to almost be adapted with some flexibility in terms of, not trying to overly restrict the way in which you conduct business. Hopefully that's a helpful answer, Gary Kemp. I think the next question is whether we'll be tasked with producing a certificate to customers that we have, basically when they've requested to have the information destroyed. So basically, a data subject will be able to ask for information to be destroyed, right? And in order for them to be able to get comfortable that the information has been destroyed as per the requirements, or to provide evidence of that, it's not an obligation to confirm it to them, but it's a good practice approach to respond with your confirmation, because it's also an ability to prove to the regulator after the fact, if there's a complaint, that this is the steps you've taken to respond to the request, and here's your destruction certificate as well. It is a best practice model in the sense of engaging with third-party providers who provide information to process on your behalf to request this destruction certificate. But engaging with data subjects directly, there's not really an obligation to provide them a confirmation of such activity having happened. Can we use the deletion report generated from IT, or can we convert that into a certificate? Absolutely, that's a very practical way of dealing with the request. And again, this is just important for me to note, is you don't need to change your process and come up with a wholly new system. You can use the practical, reasonable measures that exist in an organization to be able to facilitate certain of these requests. So that is a very practical solution, and will be able to achieve your ability to evidence compliance with the Act.
There is another question. I don't know if these have been sufficiently addressed, but there's one from Etienne, which was in the question and answer. My question may be linked to Sandile's previous question, but TransUnion allows the loading of a default payer. Is this going to be allowed come 1st July? This info would then be available to the public. Anyone doing any sort of credit check on the data subject would see this.
Yeah.
So
actually, it's a very good question. So let me just unpack that. So the first point is obviously TransUnion is the one who's the responsible party maintaining the database. So the responsibility would sit with them to ensuring that they have a lawful justification for providing this information. Now, where it becomes a bit difficult is in a sense of it creates, I would say, not a black mark, but it creates almost a limitation on the data subject to be able to exercise their rights in terms of law, and they almost have there's decisions made about them without an ability to have some type of intervention, etc. So what I do believe is that in those kind of scenarios, there might be an element of request from the regulator to kind of see the bases for certain databases being created in this manner. But at the same time, I do believe that once you've consented to your information being subject to a credit history check, all these kind of things, especially when you're dealing with TransUnion, you give that data subject is giving up consent to all these types of activities, which would include being part of this database. So it's kind of there's an element of there's lawfulness, but there's obviously the ethical element of where it's kind of causes a discomfort or a lack of an ability of a data subject to engage with the market, etc. But at the same time, as long as it's a lawful basis, it's compliant with the law, I can't see an issue. But at the same time, I feel the regulator is quite, leaning towards protecting data subjects' rights. And if that data subject objects to it or withdraws its consent, TransUnion would have to then release that information from that database.
Because TransUnion is the responsible part of us. So they would have to make sure that all their processing activities are compliant. It's not on Savrala.
It's not on the requesting party to have that justification for having that information. If the requesting party goes and sees that information that's being prepared and housed in TransUnion's database, that would be more of an issue with TransUnion's side. But at the same time, TransUnion would obviously have to look at its own processing activities and find its own lawful justification and potentially have a legal opinion waiting ready for the regulator.
Thank you very much. We're just 1 minute, over the scheduled time, but I must extend my thanks again once more to yourselves. Guys, I think this was a very, very informative session, as can be seen. Our participants have been stable. We have not lost a lot, they've stayed on because it's an interesting subject. May I just repeat again to our members, thank you for your availability. We will certainly make both the presentation and the recording, even the YouTube link available to yourselves so that you can reflect. We always try to make sure that we provide some level of value, whereas you can imagine we're inundated with all sorts of marketers, but this is not a marketing thing. And I'm sure that, Savanna, they're available to assist, our members as well, individually in their businesses. And I'll make your details available to them as well, so that at least should they, have specific questions that relate to their business, the operations, then they're at least able to get that information as well. On that note, let me thank the members for attending, and thank you very much, Savanna. And, I really thank you for a really great informative session. I think the two of you did great work. Thanks, Gary, isn't it?
It's Bruce.
Yeah.
Oh, Bruce. Yeah, Bruce. Yeah, thank you very much. It really was a pleasure. On that note, I think the meeting is adjourned. Unless there's anything else you wanted, a closing note from yourself, Savanna?
No, that's fine. Thank you everybody for listening in. And if you have any questions, please feel free to reach out to me on the contact details as well. Perfect. Thanks all.
Thank you. All right.
Bye-bye.
Then. Cheers. Bye-bye.